Okay, good day everyone. So we're going to be discussing Article 14, which is aggravating circumstances. Okay, let me share to you. So aggravating circumstances, if present and without any mitigating circumstances, no, would increase the penalty to its maximum period. Unlike in mitigating circumstances, if present, no, and without any generic aggravating, will reduce the penalty to its minimum period. Okay, so let's have a review of penalties. So you have capital punishment, which is death, then reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto menor. Duration of the penalties: 1 day to 30 days. Arresto mayor is 1 month, 1 day to 6 months. Prison correctional is 6 months, 1 day to 6 years. Prison mayor is 6 years, 1 day to 12 years. Reclusion temporal is 12 years, 1 day to 20 years. Reclusion perpetua is 20 years, 1 day to 40. Okay. Now, there are classifications of penalties. So we call this death and reclusion perpetua as indivisible penalties. Down will be divisible penalties. Now, what do you mean by divisible penalties? It can be divided. Now, within a particular penalty, it can be divided into 3, which are the minimum, medium, and maximum periods. Like this one. Reclusion temporal. You divide this into 3, then you have the minimum, you have the medium, you have the maximum periods. Likewise, pati sa prison mayor, you all have the same. So you have the minimum, medium, and maximum period. Now, pagdating sa mitigating circumstances, no, it will lessen the penalty to its minimum period. Pag aggravating, it will increase to its maximum period. Ergo, the rule of offsetting, appreciation of this, what we call as modifying circumstances, which are the mitigating and aggravating, are only applicable to divisible penalties. Supreme Court said that in reclusion perpetua, although it carries the penalty of 20 years 1 day to 40 years, it is still deemed as indivisible penalties. So silang dalawa, death and reclusion perpetua, does not have the minimum, medium, and maximum periods. So regardless of any ordinary mitigating and generic aggravating, then it will not affect the penalty. Okay? So remember, indivisible penalties, there are only 2, death and reclusion perpetua. Divisible penalties are all the rest. Okay? Yun. So, you know that insofar as mitigating circumstances, there are 2 types, 2 kinds. Ordinary mitigating and privilege mitigating. Ordinary, if present, as I mentioned, it will increase, lessen the penalty to its minimum period. Now, pag privilege, we don't talk about the period. Remember that. When you talk about privilege, we talk about degree. Pag ordinary, mitigating, okay, we talk about period. So, if there's a privilege mitigating circumstance, at least you'll now appreciate, no? You will have to identify what are the ordinary mitigating circumstances and what are the privilege mitigating circumstances. Bakit natin pinag-aaral yan? Because after the midterm exam, we'll go into detail. So you will have to look. First of all, you have to identify what are those mitigating circumstances present. Now, if you're not able to memorize all the mitigating, mawawala na kayo. Babagsak kayo sa final exam. So dapat, it's mandatory that you will have to memorize what are the mitigating circumstances and its requisites. No, it's not enough to memorize, but you don't know the elements. Pamia, you thought that it was voluntary surrender, but it's not voluntary surrender because the accused did not volunteer to a person in authority or an agent of a person in authority. Diba? So yung mga requisites yan, dapat alam nyo. Now, you will also have to identify what are the privilege mitigating. A privilege mitigating circumstances, we know that minority can be an exempting circumstance. No, it can also be a privilege mitigating one. Like what? Let's go back to mitigating circumstances. If the age of the child is 15 years old or below, that's an exempting. No? What is the consequence? Acquittal, case dismissed, because it is exempting. Wala nang consideration as to the aggravating or what. Also, if the age of the child is above 15, below 18, acting without discernment, no, then it's also an exempting circumstance. So you don't have to look into other circumstances. You don't have to count on other mitigating. Wala naman siyang exempting na yun. So exempted na siya sa criminal liability, dismiss ang kaso. Now, if the penalty is, if the circumstance is that he is above 15 and below 18 and acting with discernment, that is not an exempting circumstance. It is a mitigating circumstance. And what type of mitigating? That's a privilege mitigating. Sinabi ko sa inyo, di ba pag privilege, it will be lessened by 1 or 2 degrees. Diba? And it's usually, it's only, in its application, it's 1 degree lower. So degree. So from reclusion perpetua to reclusion temporal, what's 1 degree lower? It's reclusion temporal. Right? Yan. Yan. Maraming may gusto ng kulay pink ngayon, di ba? Ewan ko, siguro kung yung mga nakakakinig ng news, no, you know what I mean. Pagka 2 degrees lower than reclusion perpetua, 1 and 2, so it's a prison mayor. As I mentioned kanina a while ago, pag privilege mitigating, kapag ordinary mitigating, it refers to a period, right? So it's not applicable to death or reclusion perpetua. So kahit na maraming ordinary mitigating, if the penalty is death or reclusion perpetua, it will not be considered or appreciated to lessen the penalty. But insofar as privilege mitigating, we don't talk about the period. So privilege mitigating is applicable even if it is what is involved is an indivisible penalty. So if it's reclusion perpetua, and yung kanina sinabi ko, example na alam mo, 17 years old, acting with discernment. This is a privilege mitigating. And if the penalty is reclusion perpetua, you lower it by 1 degree. 1 degree. And if there are no mitigating, ordinary mitigating, and no aggravating circumstances, generic one, you will apply the medium. Next. Ano pang understanding niyo sa privilege mitigating? Di ba yung elements of justifying. If the majority are present, then it's privilege. Like self-defense. Self-defense, you have URL, right? Unlawful aggression, reasonable necessity of the means employed, lack of sufficient provocation. This is the subject of your recitation before. If 1 and 2 are present, then it's privilege. If 1 and 3 are present, it's a privilege mitigating. If only unlawful aggression is present, it's an ordinary mitigating. If a second and third are present without the unlawful aggression, then it's not a mitigating circumstance. Walang kinalaman, di ba? So, halimbawa, 17 years of acting with discernment, bababayan ng by 1 degree. Or if 1 and 2 and 1 and 3 are present, that's also privilege mitigating, baba ka pa rin. Diba? If the penalty is prison mayor and there's unlawful aggression, there's reasonable necessity of the means employed, baba ka from prison mayor, baba ka ng prison correctional. If unlawful aggression only is present, no? But the other two are present, minimum period. No? So that's the significance of appreciating, mitigating, and as well as generic aggravating. Okay. Now, we will go into aggravating circumstances. Aggravating, you have generic, Article 14. This is Article 14. This is Article 13. Generic aggravating, you have specific, you have special, you have qualifying, you have inherent. When I talk about offsetting, I'm talking about circumstances where there is an ordinary mitigating as well as generic aggravating in one particular case. No? So in one part, halimbawa, merong may treachery. No? Merong treachery, pero he voluntarily surrendered to the person in authority. So you offset one from the other. No? The ones that you're going to use only for offsetting, remember this class, it's only an ordinary mitigating from that of a generic aggravating. Ang ordinary mitigating and generic aggravating offsets one another. If there is specific, special, qualifying, inherent, do not offset it with an ordinary mitigating because it will not be appreciated. If you only see a privilege mitigating, regardless of the number of or a generic aggravating, regardless of the number of ordinary mitigating, you lower it by 1 degree. No? Baba ka ng degree. Pag ganun. When talk about privilege mitigating, vertical. Pag ordinary, horizontal. Pag specific, it only applies to a particular case, a particular crime or felony. Intent to kill applies to homicide. Intent to gain it applies to robbery and theft as well. No? Special, it also applies to a particular felony and it cannot be offset by any mitigating circumstances. Pag sinabi ng batas, like sa complex crime, no, it should be applied in its maximum period. Dapat maximum period regardless of ordinary mitigating. Pag qualifying, it changes the nature of the crime. No, importante lang dito, ito generic saka qualifying. Changes the nature of the crime. Like, when you study treachery is qualifying in the crime of murder. No? Treachery is a qualifying circumstance in the crime of murder. But in all other cases, it's only, sometimes it's inherent, no? And sometimes it's only a generic one. So that you must be able to identify what are the aggravating circumstances, number one. Number two, you need to identify how it was used. Is it generics? Is it qualifying? Or it is inherent? Inherent, it is an element of the crime. So you don't consider it. Let's go back to qualifying. Like treachery. Treachery is one, sa Article 248, kung may caudal kayo, it defines what murder is. And it gives what are the qualifying aggravating circumstances. So homicide and murder are similar but not identical. Similar in the sense that there is intent to kill. Okay, what is the difference? If the qualifying aggravating circumstances enumerated under Article 248, yung Article 248, it defines murder. No? Then it's murder. Now, if these circumstances are not present, then the crime is homicide. So marami yan, no? Maraming circumstances, treachery, evident premeditation, cruelty, outraging at the corpse, di ba? And on occasion of conflagration, etc., etc. No? Inherent. Inherent is an element of the crime. So you don't use that to offset an ordinary mitigating. Sample lang yung una, the first circumstance under aggravating circumstances will be the use of a public position. He uses public position in order to commit the crime. Now, kailan yan inherent? Inherent yan kung ang crime is malversation. Inherent na yun na malversation cannot be committed without taking advantage of his public position. So you don't offset that to an ordinary mitigating. No? Huwag mo siyang i-offset. No? Kasi inherent na yan. So, ano ba? Arson. Arson is, pwede ba mo sabihin, he is charged with arson with aggravating circumstance of use of fire? Hindi, because it's already inherent. Okay? Yun. So remember that. Bakit ba? Ano significance dito? How do you offset? And this is the rule. Sa divisible penalty. Well, this will be, I will not give this to your midterm examination, but I'll just want you to understand this. But in the final examination, I will give this to you. Mitigating and aggravating. Pag zero mitigating, zero aggravating, we talk about period, di ba? So it's medium. Like halimbawa, reclusion temporal ang penalty. May medium, may minimum, medium, maximum. Kung if there is no ordinary mitigating as well as no generic aggravating, you impose it in its medium period. If there is zero mitigating, one aggravating, then you apply it to its max. So yan. If there is one mitigating, zero aggravating, then dito yan sa minimum. Yun. Paano kung pareho sila present? Merong isang mitigating and there's also another one. One ordinary mitigating, one generic aggravating. Then you offset one another. Then you have the medium period. If there are two aggravating circumstances and one mitigating, and then it should be in the max. Dito siya. That is why I'm just showing you the significance. For the simple reason that you will have to understand both the mitigating and generic aggravating and mitigating and aggravating circumstances. You have to master that. You need just by merely looking at the facts of the case, you can already distinguish what are the mitigating and what are the aggravating. And you can be able also to identify the ordinary mitigating from the generic aggravating. Now, if you're not able to memorize this, lagot kayo. Bawa, in the facts that was given, no, there is irresistible force. Binilang nyo as mitigating circumstance ang irresistible force. Is that proper or not? That's not proper. Why? Irresistible force is what kind of circumstance? It is an exempting circumstance. So if it is an exempting circumstance, you do not offset, right? What must you do? You acquit already the accused because it exempts him from criminal liability. Kuha. Sige. So I'm just saying to you that you will have to master the mitigating, the aggravating circumstances. You will have to memorize them all. You need to also not only to memorize but to master it. No, you've got to know all the elements under each of the mitigating circumstances. Halimbawa, passion and obfuscation. Nagselos yung tao. Hindi, married siya, may girlfriend siya. Okay, will you consider that as a mitigating circumstance? No. Right? So, akala mo mitigating pero hindi pala. So, wag mo siyang sasama sa equation. Paano may ka-aggravate? Merong isang generic aggravating. O di, maximum mo lang siya. Pero hindi mo siya i-offset because there is no mitigating. Right? So, remember, in mitigating circumstances, analogous circumstances may be allowed. But insofar as the other one, aggravating, walang analogous circumstances that we've studied. Okay? Let's go to each of the circumstances. Can you see this, class?
Yes, Dean.
Let's go to Article 14. Number one is advantage be taken by offender of his public position. So it doesn't follow that just because a crime is committed by a public servant or public officer, then you will consider that as an aggravating circumstance. Okay? And if you see this, and if you consider this as aggravating, no, then you'll have to consider also if what type of aggravating is this? Advantage be taken by the offender of his public position. So, therefore, if he did not take advantage of his public position in order to commit the crime, then this will not be considered. So the question that you need to ask, did the offender use his public position in order to commit the crime? If yes, then it's aggravating. If not, then it's not aggravating. Okay? Now, you are able to identify this already as an aggravating circumstance. And tatanungin mo ngayon, generic ba yan? Baka maging inherent. Di ba? Like what? In the crime of malversation, as I've mentioned to you, malversation is committed by an accountable public officer. The person who commits malversation is an accountable public officer. So it's inherent in the crime of malversation. It is deemed as an inherent aggravating. Ergo, do not appreciate this to offset an ordinary mitigating because it is not generic when it was used. It is used as inherent one. Gaya ng sinabi ko is it's the rule of offsetting is only applicable to generic aggravating and ordinary mitigating. Ano pa? The crime of bribery. Okay? Bribery is committed by a public officer. No? He was bribed and who took advantage of his public position. So though it's an aggravating in both in circumstances, but it was used as an inherent one. So do not appreciate the same. Next. Second, that the crime uh, that the crime be committed in contempt of or with result to insult to public authorities. In contempt of or with insult to the public authorities. The most important thing here is that it was not directed against the public authority. The crime was committed in the presence of the public authority, but it was not against the public authority. Why? Because if it is against the public authority, then it's no longer an aggravating. It becomes a crime, which is what? Direct assault. Because direct assault is committed against a public authority. So, ibig sabihin yan, there are at least three persons involved. Halimbawa, si barangay chairman is a public authority. A killed X in the presence of barangay chairman. So A knew at the time that B is a barangay chairman. But regardless of he being a barangay chairman, he killed X in his presence. It did not dissuade him from committing the crime. So parang he was disrespected by in contempt of or insult to the public authority. Andiyan na si barangay chairman, hindi mo nirespeto, pinatay mo pa rin si X sa presence ni barangay chairman. No? Now, if it is directed against the barangay chairman, silang dalawa lang. Ano yan? The crime is direct assault. So this is not what is being contemplated here. No? Okay. Next. That the act be committed when insult or disregard of the respect due to the offended party by on account of his rank, age, or sex. or that it be committed in the dwelling of the offended party. Okay. So depende to pag rank, no, it depends on the status of the person, kung kilalang kilala siya, di ba? And that it was committed in disregard of the uh, uh, party's social status, then it may be deemed as an aggravating circumstance. Likewise, kung matanda siya, sobrang tanda niya, no? Tapos ang offender bata lang, it could be deemed as an insult or disregard. Okay, when you talk about sex, it pertains to a female person, no? But do not consider this in the crime of rape, because in rape, sex is the female gender is inherent, no? So first way of committing rape, then the victim is a woman. So if it's a woman, do not use sex as an generic aggravating circumstance. Dwelling. Dwelling is an aggravating circumstance because it disrespects a person's dwelling, no? Sanctity of his house. Now, what are the principles in dwelling? Kung kung pinatay siya sa kanyang dwelling, then that's an aggravating circumstance. If a person killed another one, he shot the victim outside the house, but the victim is inside the house, then dwelling is also appreciated. Now, if both the accused and the victim, the offender and the victim, they live in the same house, then dwelling is no longer appreciated. Hindi na appreciated ang dwelling. But there are circumstances where, again, this is inherent aggravating and not generic aggravating. Saang kaso? Robbery with force upon things, because it happens inside the dwelling of the offended party. Next, number 4, abuse of confidence or obvious ungratefulness. Abuse of confidence. The confidence must be personal. Okay, halimbawa, si father will be going abroad and he has his best friend, si B. Kumpare niya, no? Tapos si daughter niya, na minor lang. Sabi niya kay best friend, take care of my daughter. I'll be attending the seminar for 3 days and I will entrust you, my daughter, to you. So he went abroad. Unfortunately, si B, best friend niya, binetray siya by molesting his daughter. Question, is there abuse of confidence? Okay, there's abuse, right? But does it fall under contemplation of paragraph 4? No. Talaga? Why? Because sabi natin, abuse of confidence must be personal. What does it mean? Ito bang si D, who is the victim, does she have any relationship of confidence between D and B? Wala, di ba? It is between, the confidence repose is between F and B. But the victim is not F. The victim is D and B. So it is not applicable in this particular case. Ha? Kasi si D at si B. Dapat ang offense that B should commit is directed against F himself. No, because to be aggravating, it should be personal. Next, that the crime be committed in the palace of the chief executive or in his presence. So, sa Malacanang yan, di ba? Or in a place dedicated to a worship, religious worship. So, ito, These are circumstances where a place is deemed to, if the place is very material, it becomes an aggravating circumstance if if it is committed in these places mentioned, which is the palace of the chief executive and the place dedicated to religious worship. So it's Malacanang, it's a church, a Catholic church, or whatever church we have. Huh? And then we have, of course, or if committed in his presence, in the presence of the president, or where public authorities are engaged in the discharge of their functions. Okay, next. Number 6, that the crime be committed in nighttime. Nighttime, uninhabited place, or ban. Okay, nighttime, uninhabited place, and by a ban. Whenever such circumstances may facilitate the commission of the crime. So, nighttime uninhabited place and a ban would not be appreciated if it did not facilitate the commission of the crime. So dapat yan nighttime, uninhabited place, ban should facilitate the commission of the crime. So it should facilitate or have taken advantage. The offender have taken advantage of nighttime uninhabited place or by a ban. If he did not, halimbawa, casual lang yung pagbit ni A and B, bumili lang ng yosi sa cigarette sa sari-sari store, yung pala may existing grudge na between X and Y, pinatay ni X si Y, then nighttime is not appreciated. So, dapat it facilitated the commission, the crime, or he have taken advantage of nighttime, uninhabited place, and by a ban. When you talk about nighttime, what does it mean? From dusk to dawn. Meaning from the beginning until the end, no, it should be under the cover of darkness or nighttime. So nagsimula siya ng alas 12 ng gabi, natapos ng 3 o'clock ng umaga. No? Mga ganun pagkakataon. But if it started in nighttime, but it ended in the halimbawa afternoon, then nighttime will not be appreciated. Ginawa yung pagnanakaw alas 4 ng gabi, natapos ng alas 10 ng umaga. Nighttime will not be appreciated because dapat yan is, no, he have taken advantage of nighttime, no, from the time that he started until the time that he ended, no. He was under the cover of darkness. Uninhabited place. What is an uninhabited place? Uninhabited place doesn't mean, it does not necessarily mean that we are referring to a distance. No. It is, ang tinatanong doon is whether he had an opportunity to receive help. Was there an opportunity to receive help? Bawa, si X and Y. Few meters lang ang kanilang pagitan ng bahay. But in between is a river. No? Something happened to X. Can Y immediately respond, although a few meters only, but in between is a river na malalim? He cannot. Diba? So even it's not a distance where if it is remote to receive, in this case, it is remote to receive help. So that can be deemed as um, uninhabited place. Kung sila lang magkapit-bahay sa isang lugar, eh merong sapa na malalim, so that can be deemed as uh, uninhabited place and thus an aggravating circumstance. When you talk about ban, what does it mean? Ito na, whenever more than 3 armed malefactors shall have acted together in the commission of the crime. Okay? Acted together. Armed, more than 3 armed malefactors. Ibig sabihin yan, at least 3 or 3 or more than 3. It's more than 3. When you talk about more than 3, how many? It's what? At least 4. Ha? So, pag sinabi more than 3, maraming nagkakamaling students dito. They all the while thought that it means 3 or more. That's wrong. More than 3 means at least 4 armed malefactors that have acted together in the commission of offense. Okay, next. Seven, that the crime be committed on occasion of shipwreck, earthquake, epidemic, or other calamity or misfortune. I think this is self-explanatory. If you have taken advantage of those calamities in order to commit the crime, then it's appreciated. Okay. Number 8, with the aid of armed men or persons who ensure or afford impunity. Aid of armed men or persons who ensure or afford impunity. So he relied on the presence of armed men in order to commit the crime. Next. That the accused is a recidivist. No? Who is a recidivist? Is one who at the time of his trial for one crime shall have been previously convicted by final judgment of a crime embraced in the same title of the same code. So they have the crime that was committed is embraced. Magkayakap sila. Magkasama sila sa same title of the code. Ano ba mga title niya? Crimes against persons, crimes against chastity, okay? Crime against property. Yeah? Okay. So this pertains to recidivism and then talks about reiteration. Usually, you will be asked, distinguish recidivism from reiteration. Okay? Yung reiteration, previously punished. So, convicted na siya. And serve sentence. For an offense which the law attaches an equal or greater penalty, or for 2 or more crimes to which it attaches a lighter penalty. Well, the difference in recidivism is that those 2 crimes are embraced in the same title of the code. That's one. In reiteration, it's not. It's not necessarily in the same title of the same code. Ito is previously, second, recidivism, it's enough that there is previously convicted. But here, insofar as reiteration is concerned, it's not only convicted, but already served sentence. Ibig sabihin, nakulong na siya. Ito, convicted lang. At hindi embraced in the same title of the code. Next, number 11. The crime be committed in consideration of a price, reward, or promise. So price, reward, and promise should be the inducement. Without the prize, without the reward, without the promise, the crime would not have been committed. Next, 12. Crime be committed by means of inundation, fire, explosion, poison, stranding of a vessel, intentional derailment, thereto, tensional damage, derailment of a locomotive, or by the use of any artifice, including gateways and fuel. This is also, if used in murder, kung murder to, it becomes qualifying. Pagka-murder, qualifying siya. Pag present to, ang crime is murder, hindi homicide. Okay? Of course, when you talk about fire, no, inherent in the crime of arson. Actually, how do you commit arson? It's the use of fire. So it's not to be considered as a generic aggravating. Okay? Next, evident premeditation. Yung sabihin, pinagplanuhan, pinag-isipan. What are the requisites? Requisites of evident premeditation is tal. The time that he uh, decided to commit the crime. So, nag-decide siya to commit the crime. Second, acts, no, manifestly showing that he clung. This is the magic word, clung. Pag magbabar kayo, kalilimutan yan pagka evident premeditation. That he clung to his determination to commit the crime. Acts manifestly showing that he clung to his determination to commit the crime. Kung sinabing clung, he has time to meditate. He has time to reflect upon the consequences of his act. So, dapat mapakita yan sa facts of the case. Yes, time to meditate, reflect, and to have a cool or sinasabi doon, serene thinking. Time to think. Next, lapse of time. Sufficient lapse of time. Between what? The time that he decided to commit the crime and the time that he actually executed to commit the crime. Sufficient lapse of time from the time that he decided to commit the crime up to the time that he actually executed or performed the act. Yun. So, time that he decided, acts manifestly, A, that he clung to his determination to commit the crime, time to meditate, reflect, there's a cool and serene thinking, and then there is also sufficient lapse of time from the time that he decided to commit the crime up to the time that he actually executed or performed the act. Graft, fraud, disguise. Actually, disguise is to conceal his identity. No? When you talk about craft, fraud, there is trickery, intellectual trickery as well. No? Here, disguise is to conceal his identity. Next is 15, that advantage be taken of his superior strength and employment to weaken the defense. Superior strength, there is a hindi proportion, disproportionate notoriety, no? Between yung ginamit ng strength ng victim and that of the accused. If you have taken advantage of the superior strength, then it will be liable as such. If not naman, then it will not be considered. Treachery. You talk about treachery, importante ito. Let me give time to discuss on treachery. Treachery. You have to memorize treachery. Memo. Memo. And the definition as well as the requisites. Lumalabas parati sa bar yan. Pag na-memorize yan, papasa kayo ng bar. Sigurado may tanong yan. Requisites. Because treachery is a qualifying aggravating in the crime of murder. First one is that there is no opportunity for the victim to defend himself. So no opportunity on the part of the victim to defend himself. So example would be the crime was committed, which is sudden and unexpected attack. There's sudden and unexpected. Sudden and unexpected attack. What else? He had no inkling that his life is in danger. Wala siyang inkling. Like, halimbawa, the crime was committed when they're about to handshake. Actually, nag-handshake sila, tapos biglang sinaksak ni A, si B. What else? Mga decisions on the Supreme Court. Kaya nagpasindi ng sigarilyo. Tapos habang kumuha ng pasindi ng sigarilyo, sinaksak niya. It came as a sudden and unexpected attack. Or B was texting. No, nakatalikod siya sa A, sinaksak si B. Nakatalikod si B, sinaksak ni A si B. Okay? So the attack was sudden and unexpected. Usually, treachery is shown when the attack is from behind. But not necessarily, but mostly lang. Even if for as long as there's the opportunity to defend himself. Can there be treachery? Ang tanong, if halimbawa is face-to-face sila, yes. If again, the attack is sudden and unexpected. And the victim had no inkling that his life is in danger. So nagsasayaan pa sila, kumakanta pa bilang sinaksak ni si B. Okay? Now, notice that it does not mean that he had actually able to defend himself. It is only an opportunity. This is where mostly the students got their mistake. No? Bawa si X and Y. Then we have A. A and W are friends. Sabi ni A, "Hoy, ang nasa taas siya ng nasa roof deck siya ng house niya. You have to run because X is after you and is carrying a balisong." So takbo ngayon si A, si W. He was actually forewarned. Nakatakbo siya, malayo pa eh. But because X is so strong and is able to outrun Y, and then he was able to overpower Y. X indeed stabbed and killed W. So in fact, Y was able to parry it at some point in time, but because X was so strong that he was able to parry W. Okay, is there treachery? No treachery. Why? Because there is an opportunity for the Y to defend himself. In fact, he was able to run. In fact, he was able to parry certain blows of X, but because X was so powerful, superior in strength, that he was able to overpower W. But it does not end there. No? It does not end on the first requisite. The second requisite is that must be consciously and deliberately adopted. Consciously and deliberately adopted to ensure its execution. And it doesn't stop there. It says here, um, without risk arising from the defense which the offended party may make. Ibig sabihin is that to eliminate the chance of self-defense on the part of the to eliminate the chance of self-defense on the part of the victim. So consciously and deliberate adopted. Sabi ni X sa ni Y, okay, patayin natin si A ng alas 2 ng umaga. A.M. For sure, he is sleeping. So yun, it was consciously and deliberately adopted to ensure its execution. So pinatay siya nila at 2 a.m. when they know that A is sleeping at that time. Now, the killing of a minor child is deemed to be treacherous. Treachery din yun. So remember that these two elements must concur. So if you're gonna argue that a person, that there is treachery, you have to lay down the requisites first, this one. Then be able to apply these two requisites to the given facts. Remember, class, whenever you write your answer, there must be a legal basis. Hindi pa pwedeng logic lang ng logic yan. Pag walang legal basis yan, mo hinugot yung sagot mo, then it will not be given any credit kung paikot-ikot lang. So if I'm asking questions pertaining to the circumstances, mitigating, aggravating, or whatever, be able to answer it by having a legal basis and by stating the requisites. So yun, that I would know kung napag-aralan nyo o hindi yung ano. Saka, even in other subjects, pag walang legal basis yan, hindi pwedeng paikot-ikot lang yun. Your professor would know. First of all, identify the legal basis, as I always mentioned to you. So, the law itself, settled principle, the requisites of the law, those are the legal basis. And then be able to identify the same. Be able to apply the same to that particular case. No? Let's continue. Okay, the treachery is also deemed as alevosya. So, yun ang sinabi ko sa inyo kanina. There's treachery when the offender commits any of the crimes against persons. So this is applicable to crime against persons. Okay, employing means, methods, MMF, the execution thereof, which tends 10 directly, especially to ensure its execution. Okay? And to eliminate self-defense. This is sabi ko, without risk to himself arising from the defense which the offended party might make. Next, that means be employed or circumstances brought about which add ignominy to the natural effects of the act. Ignominy is sometimes asked with cruelty. Cruelty is that which is that under paragraph 21, that the wrong act done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Erase muna tayo. Clear. Yeah. So differentiate ignominy from cruelty. Paragraph 21 is cruel. Ignominy is moral suffering. Cruelty is there's physical suffering or physical pain. Moral suffering, there's also to bring the victim into humiliation. Okay? Ignominy. Killing a person in the killing the husband in the presence of his spouse is deemed to be ignominy. So, di ba? Pinatay yung asawa niya, sinadyang patay yung asawa niya sa presensya ng kanyang wife. So, there's ignominy there. Or in one case decided by the Supreme Court. So, the offender is the male servant na nagkaroon ng sama ng loob sa kanila. So, ninakawan sila. But before this male servant killed these two spouses, he required them to kneel down before him first. Lumuhod sila in the presence of this male servant before he shot and killed these spouses. Kawawa naman. So bakit pinaluhod? So nagmakaawa. So that is to bring them to humiliation. There's moral suffering to it. You talk about cruelty. Cruelty is a physical pain which is not necessary for its commission. Kung papatayin lang, patayin lang. Ngayon, bago pa pinatay, pinag-suffer muna siya ng mahaba. No, that's cruelty. So the placing yung binasa niyo libro, the placing of a cogon grass, di ba, sa genitalia ng female person, the victim, female victim is deemed to be an act of cruelty. O siguro bago patayin yung isang tao, tinali muna sa isang tree, sa isang puno at nilagyan ng isang sakong mga langgam, buong katawan, until he died. So he enjoys seeing the person suffering physically. That's cruelty. Okay, so let's go back to 18. That the crime be committed after an unlawful entry, there is a lawful when an entrance is effected by a way not intended for a purpose. Okay, this is inherent in the crime of robbery with force upon things. Plus, there are two kinds of robbery. One is directed against the person. Pag against the person, gumamit ng violence or intimidation. Another type of robbery is that with force upon things. So, tungkol na sa property yun. No? So, kung nag-rob yung isang tao ng loob ng isang bahay, no, that's robbery with force upon things. And accordingly, yung sa robbery under Article 293, robbery is committed by 294 uh, by unlawful entry. Robbery with force upon things by breaking the wall, roof, door in order to effect entrance or through an unlawful entry where entrance is effected by a way not intended for that particular purpose. So do not appreciate this as a generic aggravating in the crime of robbery with force upon things, because in this case it is used as an inherent aggravating circumstance. The same also goes with paragraph 19. The commission as a means to the commission of crime by wall, roof, floor, door, or window being broken. So it's also inherent in the crime of robbery with force upon things. So do not appreciate that as a generic aggravating. Number 20, which is the last one. That the crime be committed with the aid of persons under 15 years of age. Under 15 years of age. And by means of motor vehicle, airship, or other similar means. Now, let's talk about motor vehicle. Okay? Ginamit ang motor vehicle as a way of escape. After committing the crime, they did not use the motor vehicle. Now, in the execution of the crime or where the crime is committed, but they use the motor vehicle as a way of escape. Question, will this be appreciated as an aggravating circumstance? No. Why? Because it was used as a way of escape. It is a settled doctrine that if a motor vehicle is used not in the execution of the crime but as a way of escape, as a means to escape, then it is not appreciated as such. Okay? Tapos na tayo. Next. Alternative circumstances. Okay. Okay, we'll end this lecture.